Please be seated. And we're on record. This is Timothy White versus Clark County. Can we have introduction of parties and counsel then, please?
Your Honor, my name is Jane Beto. I am here for Clark County.
I'm sorry, what's the name?
Jane Beto.
How do you spell the last name?
It's V as in violin, E-T-T-O.
And
Your
counsel?
Honor, I'm Mark Zemmel here for Timothy White.
Mark, what was the last name?
Zemmel, Z as in zebra, E-M-E-L.
And you're Mr. White?
Yes, black
Okay.
and white.
Very good. Good afternoon. So you may have heard I'm sort of the hot potato ended up in my lap, I guess, on fairly short notice. So honestly, I've reviewed some materials, but I'm fairly fresh to the case and fairly fresh to this area of law. So if the party, I'm not going to fault the parties for taking a wide turn in terms of fleshing out the arguments for today's hearing. Okay, this is it your? I guess it's in order to show cause.
Yes, sir.
So it's your argument, I suppose.
Okay. And should we approach the...
You're welcome to argue from counsel's table. That's fine.
Okay. Well, Your Honor, as I said, I'm Mark Zemmel, and I'm here with Timothy White, who traveled here from San Juan Island to be here today. And thank you again for taking this matter on such short notice. Mr. White seeks to have public records that he requested under the Public Records Act immediately produced. We believe this is a simple case where Mr. White made a request for specific public records under the Public Records Act, and Clark County unlawfully withheld those documents. The Public Records Act is a very powerful statute. It ensures that agencies are accountable to the people and retains the sovereignty to the people by holding by maintaining control over the instruments that they have created. The public record, the Act defines public records extremely broadly, covering a wide range of documents. Here, it is undisputed that the records at issue are public records. The agencies are mandated to produce records upon request under the Act, unless there are specific exemptions that apply to the records requested, and that is only in very limited circumstances. Exemptions are only found in statutes themselves or in case law. They're not found in administrative practices, in the administrative code, or any general workings of agencies. And even if an exemption applies to information contained within a public record, the Act requires that that information is redacted and then the remaining document is produced. So the county has an extraordinary burden to meet here in overcoming the strong mandate to produce records. We actually have the benefit of thorough and unambiguous Supreme Court precedent that outlines agencies' duties under the Act. It says that that the Act must be liberally construed and its exemptions narrowly construed to promote the Act's public policy of openness and transparency. When there's any doubt about the application of the Public Records Act, the court must find in favor of public access. The Supreme Court has explicitly said that the purpose of open government is paramount in the Public Records Act, and the court cannot imply exemptions. They must be explicitly identified in statute or in case law. There are also no general exemptions contained within the Act. They need to be explicit and specific. And finally, even if an exemption is on point, a court may disregard it if the exemption is unnecessary to protect an individual's right of privacy or any vital governmental function, and that's contained within the Act itself. The Act is intended to be sweeping and powerful to ensure agency accountability and transparency. Indeed, the Public Records Act is as strong as it could be. So we believe the court should follow the lead of Colorado and Vermont, where completely analogous facts were at issue, where they ordered production of ballot images, digital images. Those are the records at issue here. And to walk you through the process here, in Washington and in Clark County, ballots are submitted by mail. Voters mark their choices on a paper ballot, then mail it in. The ballot is immediately scanned, and creating a digital image, and that digital image is stored on a computer with the county, and the paper ballot is placed in a secure location until they're destroyed. So there are several overarching reasons the documents should be produced here. First, it is undisputed that the files are public records subject to the Public Records Act. Second, there are no exemptions for the records in the Public Records Act itself. That's also undisputed. And there are no exemptions for the records in the Constitution or statutes, despite the arguments made in the county's briefs. The Constitution guarantees secrecy in voting, but does not impose a broad veil of secrecy over the election process. Elections are public, the counting centers are open to public observation, and the only prohibitions that the secrecy in voting provision imposes is that the ballot must be anonymous. In fact, the county is prohibited by law from creating or maintaining any record which would permit voter identification, and that's contained at RCW 29A-08161. So there really is no issue with ballot secrecy here.
What's the statute again?
29A-08161. It reads, no record may be created or maintained by a state or local governmental agency that identifies a voter with the information marked on the voter's ballot, including the choice that a voter makes. Indeed, the counties have provided no evidence that identifiable ballots are included in the request at all. And even if identifying information would be included in production, that information could be redacted and the remaining record should be produced under the Act. Clark, the county only cites to remote hypothetical situations that may compromise voter anonymity, but those are hypotheticals. They have not alleged that any of those situations apply here, and other statutes and procedures or redaction handle the risk the county identify. So they talk about small precincts that may allow for identification of individual voters, but as Exhibit 4 to Mr. White's second declaration shows, the Secretary of State has explicitly said county election departments must employ administrative methods to promote the secrecy of a ballot in precincts with a low number of voters receiving ballots, end quote. RCW 29A-6230 also says election officials may aggregate results from more than one precinct if the auditor finds that reporting a single precinct's ballot results would jeopardize the secrecy of a person's ballot. And RCW 29A-6160, quote, in order to protect the secrecy of a ballot, the county auditor may use discretion to decide when to process absentee ballots and canvass the votes. The county simply has not met their burden here to show that there's any compromising of ballot anonymity in complying with the Public Records Act and producing the records. And finally, redaction can alleviate any concerns, which is required under the Act. Now, the county relies heavily on the ballot security provisions of Washington's election laws, which require that ballots be stored in secure locations, but that is not an exemption under the Act. An exemption cannot be implied, and those statutes are intended to maintain the security of a ballot against fraud. It is not some veil of secrecy over public access. Indeed, the only statutory limitations on public access relate to touching paper ballots themselves, touching the ballot boxes themselves, or operating tabulation machines. There is nothing about seeing ballots themselves which are assured to be anonymous under the Constitution, under the statute I cited earlier. And RCW 29A-60-170, subsection 2, says proceedings must be open to the public. And also, security provisions in general are not exemptions under the Public Records Act. All public records are maintained in secure locations in order to ensure authenticity. That is fundamental to maintaining public records. And I'd refer you to RCW 40.14.020, subsection 4, which requires the state archivist to ensure the security of all public records. Public records must be produced pursuant to the Public Records Act. The fact that they're stored in a secure location is not an exemption under the Act. There are also no concerns with tampering of the election in complying with the request. In order to comply with Mr. White's request, the county does not need to access or handle the original ballots at all. Those are kept in a secure box that never needs to be open. The images are already stored on a computer, and they simply need to produce copies of the images that they already have. It is undisputed that once they're scanned, there is no need to access the paper ballots. Further, the election has already been certified, so there is zero risk of election error or tampering in complying with the Public Records Act in this case. Also, the county relies on an argument that they claim that the images themselves are official ballots, and they rely on the definition found at RCW 29A 04.008, subsection 1. But that says that ballot means, quote, as the context implies, either a physical or electronic record for the choices of an individual voter in a particular election, or the physical document on which the voter's choices are to be recorded. The either or distinction in the statute makes it unambiguous that there is only one official ballot. The images that are generated through the scanning process are not the official ballot. The context here is that voters indicate their preference on a paper ballot. That is the ballot. It is then mailed in, it is scanned, and an image is generated that the voter never saw, never had access to. It is not the official ballot. Their whole argument about applying the ballot security provisions, which are not exemptions in the first place, rests entirely on classifying these images as ballots themselves, which they're not. The definition of the ballot is to give flexibility to precincts in determining what mode of voting they want to provide. If the county used a digital voting machine where there was no paper ballot on which the voter marks a preference, perhaps then the digital record would be the ballot. But in this context, it is the paper ballots that's the ballot.
And do you cite to any controlling Washington authority for that provision?
I cite to the definition itself, which is contained at 29A 04008, subsection 1.
I'm asking if there's any controlling case authority on all fours with your interpretation, as you just
I have
mentioned.
not seen authority in either direction on that, and it is the county's burden to identify exemptions within the statute. And I just want to highlight, to imagine the headache if the court were to treat every record of a voter's preference as an official ballot. Would that would each record need to be verified? Would each need to be counted? Would each be subject to recounts as an official ballot? I think the answer is pretty clear that a record that is generated by the county itself is not an official ballot. I also want to address some of the county's secondary arguments. Those are sort of the main overarching arguments. But the county also cites an alternative means. They claim that an alternative means of obtaining the records is an exemption when that is not the case. First, the Supreme Court was explicit that, quote, the fact that records are readily available from another source is not a reason to deny a request, end quote. And that's from Lindstrom v. Ladenburg. Second, the alternative method proposed by the counties necessarily makes the intended use of the information a basis for denying the request, which is expressly forbidden by the Public Records Act. The procedures that they identify, that this alternate procedure that Mr. White should have used to obtain copies of the records, is limited to contesting an election. So limiting it to that necessarily limits production based on an intended use. And I would like to refer the court to King County versus Sheehan, which says, quote, intended use of the information cannot be a basis for denying disclosure, end quote. And the Public Records Act itself also says that persons shall not be required to provide information as to the purpose of the request, because that is irrelevant. The county also makes the argument that the images don't exist and that it would require creating a new record, which is not required. But the county confuses different formats from new records. The counties are obligated to decrypt encrypted records so they are readable by the public under the Act. And I'd refer the court to WAC 434-662-070. Quote, if encryption is employed on public records, the agency must maintain the means to decrypt the record for the life of the records. Otherwise, the Public Records Act would be completely ineffective. Any agency could encrypt any public record that they feel is embarrassing or somehow somehow detrimental to their personal interests, and that would exempt it from production under the Public Records Act. Clearly, that is not the intent of the Public Records Act. It is to make agencies accountable to the people and ensure openness and transparency. The county itself also references ballot images repeatedly and confirms they can be, quote, printed out. And I refer you to the Declaration of Garber at page 7, line 2. I mean, it's pretty clear that what they are printing is an image that shows up on their computer screen, which is a record that exists and is subject to the Public Records Act. Also, in the Garber Declaration at page 7, line 21 to 22, quote, the scanned images are converted to a proprietary format that only Ballot Now can read and process. Now that quote shows that scanned images do exist. They are records subject to the Public Records Act. And the fact that they're converted to a proprietary format also means nothing. Again, I refer you to RCW 29A 36-111, subsection 2, quote, an election official may not enter into or extend any contract with a vendor if such contract may allow the vendor to acquire an ownership interest in any data pertaining to any ballot. Claiming that a program that allows the agency to read an image is not an exemption under the Act. They need to convert it to a format that is readable by the public and produce it under the Act. Also in Clark County's email from November 12, 2013, which is Exhibit 3 to Mr. White's first declaration, they say, quote, please be assured that all ballot image files remain intact throughout the tabulation process. Again, pretty clear that these images exist, are public records, and need to be produced. The county also references criminal penalties, which also show nothing for unlawful and unauthorized removal of ballots. But again, the Public Records Act provides lawful authorization. These criminal penalties don't apply. The Public Records Act explicitly provides access to public records and mandates that counties produce them upon request. Also, in similar statutes that apply to public records in general, very similar criminal penalties are implicated. And I refer the court to RCW 40-16-010, quote, every person who shall willfully and unlawfully remove, alter, mutilate, destroy, conceal, or obliterate a record or other thing filed or deposited in a public office is guilty of a Class C felony and shall be punished by imprisonment or by fine. Again, this shows that ballots are treated very similarly, if not identically, to other public records. The security of all is paramount in order to ensure authenticity and eliminate fraud, and secure storage and punishments for unauthorized removal is consistent throughout. They are not exemptions under the Public Records Act. The county also cites hardship and inconvenience in producing the records, which is not an exemption, and that's explicit. The Supreme Court in Rental Housing Association of Puget Sound versus City of Des Moines, quote, administrative inconvenience or difficulty does not excuse strict compliance with the Public Records Act. Again, this is a very powerful statute meant to hold agencies accountable to the people, and it is especially applicable in the election context. And finally, even if the courts find an exemption applicable, the court should order production of the records under RCW 42-56-210, subsection 2, because there is no risk to anyone's privacy rights or any vital governmental function. Now, the Supreme Court has said, quote, the trial court must find that a specific exemption applies and that disclosure would not be in the public interest and would substantially and irreparably damage a person or a vital government interest, end quote. And that's from Soder versus Spokane School District number 81. There are no secrecy concerns here. Ballots are anonymous. They're mandated by the Constitution to be anonymous. The statutes explicitly prohibit the county from maintaining or creating any record that would permit identification of the way an individual voted. So there are no secrecy concerns here. And there are no vital governmental function concerns either. There's no risk of fraud or tampering. As I mentioned, there's no need to access the paper ballots themselves, which remain intact and remain the official ballot and official record of the election. and the election has already been certified. This election is over. There's no risk at all. On the contrary, it is actually in the public interest to make these records public. It promotes citizen involvement and confidence in the election process, which is the fundamental instrument of our democracy. It helps safeguards against errors, fraud, and abuse with additional public oversight. And ballots have always been processed, canvassed, and counted in public. Counting centers are still public to this day, and in the past they were even, the whole process was even more in the public domain when it was not decentralized and when counting and verification occurred at local precinct level with public observation. And I'd also just like to add that since the advent of mail-in voting, elections span over a month. Ballots trickle in order for the public to actually be able to exercise their rights to verify and oversee the election process. They would have to be sitting in the counting office for 8 hours a day, every day, for several weeks, if not months, before they could actually have a meaningful participation in the process. This, by making these documents and records public, it merely provides a more efficient way for the public to be involved and to verify the process. So I wanted to focus most of my time addressing the reasons why production of the records themselves is mandated and required. But I also want to take the time to address the procedural rules under the Act and the violations of the Public Records Act that the county committed in its lack of response to Mr. White's request. This is also very important because without compliance with the procedural rules, the Public Records Act wouldn't be taken seriously, and without identifying individual documents that are being withheld, the requester, Mr. White, has no idea what records are out there responsive to a request, and even the court's ability to conduct its de novo review is frustrated. So Clark County's final communication with Mr. White said, quote, "I will look into it, and I will be in touch on or before November 22nd, and that was in the November 13th email. After that communication, Clark County was completely silent and did not respond to Mr. White's request at all. The Public Records Act is explicit that explanations about denials must provide enough information for a requester to make a threshold determination of whether the claimed exemption is proper. By not responding at all, the county violated the Public Records Act. As I mentioned, responses also need to identify each individual record withheld with particularity. And this means a privilege log, identifying the records that were withheld, which did not occur here. So I just want to highlight that Clark County's arguments really fail on multiple levels, and they need to prove their arguments at every step, while Mr. White only needs to show that one is true. The records would need to be ballots in order for their claimed exemptions to even apply, which they are not, as the definition of ballot is explicit about. The security provisions would need to be Public Records Act exemptions, which they're not. There are security provisions for all public records, and the Public Records Act mandates production of public records upon request. The county would need to be unable to redact exempt information, which of course they can. And withholding the public records would need to be necessary to protect against substantial and irreparable damage to a person or a vital governmental interest, which, as I mentioned, are not necessary at all. Now, Vermont and Colorado have made these records publicly available, and the court should follow their lead. The sky is not falling in those states. Those records are public. They're even posted on websites for all to see. There is no violation of the secrecy of a ballot, and there have been no problems. The sky is not falling, and Washington, with its strongly worded mandate in the Public Records Act, should follow the lead of Vermont and Colorado.
Thank you. Ms. Veto?
Your Honor, may I approach? I'm getting a little bit scratchy, and you may not hear me. Thank you. Your Honor, I will try to keep this short so that I'm sure you have a lot of follow-up questions for me. But I would like to outline the county's position very briefly, if I may. The first thing I'd like to note is that plaintiff's counsel and I do agree on one thing, and that is that the issue is pretty simple here. The state of Washington has laws for accessing voted ballots, but the Public Records Act is not the way for the plaintiff to do that. Washington state laws are centered around the concern for the integrity of the election process, and Washington has all sorts of policies and procedures that are outlined in our brief for the secrecy of the ballot to be maintained. The proper way for the plaintiff to access these records, therefore, is not through the Public Records Act. It is through the election statute. And he has been told that numerous times, and I will get to that later. But for those reasons, we do ask that the plaintiff's motion be denied. First of all, I'd like to talk about a voted ballot. What is a ballot? And under the statute in Washington, a ballot is a physical or electronic record of the choice of an individual voter. Part of our motion, or in our response brief, we submitted a lengthy declaration from our election supervisor, Kathy Garber. And she goes through the process of what happens with a ballot when it is submitted by a voter to the elections division. And what happens is with our ballot, the ballot is taken out of the envelope, the signature is verified, it is immediately scanned into not a computer, into a voting machine, and then the original ballot is locked and sealed away, and that voting machine, it codes that ballot, and as she says in her declaration, the ballot is not an individual image at that point. It is a series of binary codes that we can't read. And there's a couple reasons for that. One, because we contract with the company, and that's their business, and they want to keep that proprietary information. Two, going back to the election statute, the election staff cannot go in and see this ballot and see who did what, because every ballot has a unique identifier. So this maintains the secrecy of the ballot. With respect to there only being one ballot, no. Under the statute says it's an electronic or paper ballot record of a voter's choice. And so there's two. There's the image, or there's the scanned document that's in this election machine, and then there's the ballot that has been put into the locked bin. But we can't access this data. It is encrypted. It is not an image. And there is Washington law in the O'Neill case that we cite that says you can't get digital information off a ballot because that's part of the ballot, and you can't get the metadata either. And that case is cited in our brief. So for purposes of Washington law, a ballot includes any digital or electronic version and the metadata that's associated with it. The secrecy of the ballot, again, is primary in Washington statutory law. The election statute is RCW 29A, and it is absolutely concerned from the beginning to the end with the secrecy of the ballot. Under that statute, it would be illegal for us to produce those ballots under that statute in the way that this request was made under the Public Records Act. So does that mean that voted ballots can never be obtained in Washington? No, but they can't be obtained under the Public Records Act. The plaintiff has to go to the election statute. So the two statutes that we need to talk about in this hearing are, first of all, the Public Records Act, which is 42.56.070, and then the election statute. The Public Records Statute I just referenced provides, and let me just quote it for you so I don't get it wrong. Let me read it for you. It says, each agency shall make available for public inspection and copying of all, this is 42.56.070. I'm sorry.
So you're referencing now the public records.
It says, unless the record falls within the specific exemptions of subsection 6, this chapter, or other statutes which exempt or prohibit disclosure of specific information or records. So when we get a request like that, we have to figure out, okay, are there any other statutes that would prohibit this disclosure? So because plaintiff has requested ballots, we go to the election statute. The election statute, 29A.60.110, provides that the ballots can be obtained, and they reference the containers, but under the law, A ballot is an electronic image as well. That these can only be unsealed by order of the Superior Court in a contest dispute. So if there's a contest dispute, he can get these ballots, but he needs to make that showing under this statute. Now, if he has a concern that the only way he can access ballots is through a contested statute, he needs to take that up with the legislature. But we can't change it here at the trial court level. That's the sole means, and he can do that. And the statute, the legislature can do that. The legislature can control that and preempt record disclosure under the Public Records Act. And I do have Washington case law that supports that. In the Deere case that we cite, the exact same type of situation happened here. In Deere, the plaintiff was seeking, I believe it was DHS records, and there was another statute that said you can only get those records under this statute. And the plaintiff said, no, I want them under the Public Records Act. And the court said no, because there's another statute that says this is how you get those records. So you have to move under that statute, not the Public Records Act. And again, that is in our brief, Your Honor. So again, that case is directly on point. 29A.60110 is the sole method for the plaintiff to obtain voted ballots. And I would also point out that in his public records request, which wasn't just sent to Clark County, it was sent to every county, he said time is of the essence. In case I want to contest this election, I need these right away. So that's certainly an indicator that this could be a contested matter that he could then move under this statute for. Even if the court were to find that despite this law that these records were releasable, under other Washington law, the county is not required to create a record from existing data. And I know that you were deluged today with a lot of briefing, but I would, if you haven't, I would encourage you to read our declaration of Kathy Garber, our election supervisor, because she is much more articulate than I am in this declaration. And she really sets out what happens with these ballots when they're scanned, that they're not images when they're in this machine, and it's not a computer, it's a machine. And that in order for her staff to go in and get an image, they actually have to pull up data, which is illegal with their contract with this vendor and also illegal under the statute, under the election statute. They would have to pull up this data, they would have to input it into a PC, they would have to make a record, they would have to redact the serial number, because every voter has its own, every ballot has its own serial number, which is a unique identifier. They would have to actually redact that, and they would have to create a new record. And there is case law in Washington. Again, we cited it in our brief. It's Smith versus, I know I'm going to murder this, Okanagan County, where the plaintiff requested indexes from a county. And the county said, we have the data, but they're not in index form, so we're not going to give this to you. And the court said, you don't have to. If you have the data, but you don't have it as a record, you are not required to create a new record. And that's exactly what they would be asking us to do here. Pull up, make a digital image, and then redact it and give it to them. We are not required to do that under Washington law, even if we were required to produce this record, which we are not, because they don't exist. And because it's covered by a different statute. Finally, all that aside, again, we come back to what is Washington law? What is important to the citizens of Washington? To the citizens of Washington, the secrecy of the ballot is absolutely primary. If you do look at those out-of-state cases that plaintiffs cited, in one case in Colorado, they print copies of the ballots for people to see. They have a totally different statute. In both cases, they're talking about different statutes that are totally different from what our legislature created, what our legislature thinks is important. But here in our state, our legislature has put a premium on the privacy of the ballot, and it's part of Kathy Garber's job to make sure that when someone submits a ballot, it remains a secret ballot. That's her job. And you know, the plaintiff is like, well, you can redact it. You really can't. The legislature has also created a way for people to be involved in the voting process. Voter registration lists are public. People who submit ballots, that's public. Their precinct is public. So if you're in a smaller precinct and you're turning your ballot and the plaintiff has access to these daily tallies of who's turned in their ballot, he can look up, see what precinct you are, and if you're in a precinct, which can happen, of 8 voters and only 2 have turned in their ballots, he can pretty much figure out who's voted what when. And why is that important? It's very important. It's important for people I work for an elected official. I love my boss, but I don't need him to know how I vote. Everybody in this government works for an elected official. I mean, this would have a chilling effect on voters' turnout. Furthermore, the plaintiff requested that these be produced before 8 p.m. on Election Day. If ballots are released before election, the polls close, then what happens? Well, people go, oh, it's too late for me, even though it's not. This election's already been decided. It has a chilling effect. So forget the law. The whole public policy that's important to the people of this state would be completely ignored if the plaintiff were able to access these records absent a showing under the election statute. This is not pursuant to public record. This is appropriate for him to try to access through the election statute. And he knows that, Your Honor. When the plaintiff's attorney was talking about our response, he said, well, on November 13th, they sent an email and that was it. We need to back up 4 years because our first request from the plaintiff was in 2010 for ballots. And at that time, he sent a letter saying, plaintiff, please go ahead, and it's not a public record. We can't produce these under Public Records Act, but please try to get these through this statute. And we cited this specific statute. 2 years later, he comes back in 2012. He gets an exemption log from us. He gets a letter saying, go under the election statute. We can't produce these under the Public Records Act. So fast forward another year, he gets an email saying, we're sorry, we're looking into this, but the law hasn't changed. We'll verify, but you're still not entitled to these records. Pre-tabulated, post-tabulated, it doesn't matter. It's still a voted ballot. You need to go through the election statute. So to look at our response just as something that happened 2 months ago is not accurate. You need to look at the entire dialogue that we have had with this plaintiff, including taking him on a tour of our facility, showing him the voting machine. So he has his willfulness in not following and not pursuing the appropriate law should not be something that we are penalized for. And based on that, Your Honor, based on that history, based on his desire to change the law through the courts rather than through the legislature, we really do ask at this time that his motion be denied and that we are also awarded costs in this case. Thank you.
Response brief?
I think I'll come up there too.
First of all, a couple of questions, Mr. Zemmel. Is this really a statewide issue? Is this going on in other counties? And if so, how many counties?
Well, in terms of pending litigation or in
terms of the request and or litigation corresponding to
this? The requests
this?
were made to many other counties. And
What are the 39 counties in Washington? I can't remember.
I would defer to your knowledge on that. And there is a pending.
So were there mirror requests in every other county?
Yes, Your Honor, and that's in the declaration.
Okay.
And the email with which the request was conveyed to all the counties is also in the declaration.
And may I assume there's litigation in other counties as well?
There is in Snohomish County against Skagit and Island County. It's one case.
Out of curiosity, have any other counties produced the requested information?
No, Your Honor.
Okay. Go ahead.
And I would also like to answer any questions that you may have on the merits as well. But I do want to address a few points that the county makes. Ms. Veto said we can't read the image code, and I would just like to point out that there is a specific process called ballot resolution, in which the image of the ballot is brought up on a computer screen, and election officials look at it to determine whether or not a preference was indicated on the ballot in a way that the computer program wouldn't be able to read, but that a human would be able to interpret and carry out the wishes of the voter. So it's just not truthful to say that they can't read the image code. And further, I would just like to reiterate the obligation that the counties and all agencies have to decrypt encrypted records and to convert it into a format that is readable by the public. The whole point of the Public Records Act is to make these public records available to the public, to hold agencies accountable to the people, to retain control over the procedures that the people have created, and that is directly applicable here. I also want to talk more about the ballot definition, which Ms. Beto quoted in part. But again, I would like to read, quote, "Ballot means, as the context implies," meaning there are different ballots in different contexts, "either a physical or electronic record for the choices of an individual voter in a particular election, or the physical document on which the voter's choices are to be recorded." So in applying this definition, the court, it's pretty clear that the court is to look at the specific context. In some contexts, maybe it's an electronic record for the choice. In other contexts, it's the physical record. In this context, the voter indicated his preference on a paper ballot, sent it in by mail, the county scanned it and imaged it, and that paper ballot is deposited in a container, and the image itself is maintained on a disk in code, just like every other digital file. The fact that it's ones and zeros doesn't mean anything. All digital images, when you look at it without a software program to interpret the code, is ones and zeros. When you open up a computer, you don't see a picture in it. You see silicone and circuit drives, and it contains code that is interpreted by a program that generates an image. They have the program that can interpret the code to generate the image. They can see the image, and they should produce copies of it pursuant to the Public Records Act. It's very simple. I also want to touch on the alternative means method. They say that the proper forum for Mr. White to obtain these records are through the election laws, which limit access to ballots to election contests. There are other reasons that an individual might want access to these ballots, and the purpose for requesting the record is not a reason to deny the request, and it's explicit under the Public Records Act. The Supreme Court has also held that if there's any conflict between the Public Records Act and any other statute, that the Public Records Act controls. So when an agency says, "Oh, you should have gotten this from this other process," but that process limits it to certain intent, that is necessarily in conflict with the Act and is not an exemption. I also want to highlight the quote from the Supreme Court that I quoted earlier in Lindstrom v. Ladenburg. Quote, "The fact that records are readily available from another source is not a reason to deny a request." It's very simple. The Public Records Act requires that agencies respond to requests that are made pursuant to the Act and produce the records unless an explicit exemption applies. There are no explicit exemptions here. As we mentioned, in order for the ballot security statutes that the county relies on to apply, it would have to be a ballot. These images would have to be the ballot, which they're not. And those aren't even exemptions in the first place for ballots themselves, because secure storage is mandated for all public records in order to ensure authenticity of public records. And the criminal penalties that they cite are also applicable to all public records. Public records are widely produced by agencies pursuant to the Public Records Act. This is a means that the people who enacted the Public Records Act by initiative in 1972, I believe it was, they envisioned this act to be comprehensive and to permit the people to have access to documents and records that are maintained, produced, or held by government agencies. That is the situation here. This isn't a separate situation just because it's in an election context. The election context is actually where the Public Records Act is extremely important, because that is the fundamental instrument of our democracy, and the Public Records Act is meant to retain sovereignty to the people. and maintain control over the instruments that they have created, which is elections, by definition. This is
And I guess the county's argument is that there's a qualitative difference between agencies that are taking action, that are political entities that set policies and enact, have budgets and do X, Y, and Z, versus an elections division, which is really at the core and kind of a fundamental. When I'm hearing the arguments here, frankly, what's coming to my mind, just so you know, I'm thinking back to my law school and bar examination days, and I know it's not exactly on point, but the notion of preemption, federal preemption versus state law or state versus local or what have you. And as I recall, under the doctrines of preemption, you could have express preemption that says this law is, supreme and this is the final word and final authority on this particular subject. But you could also have preemption by operation of law, and one of which was pervasive regulation in a certain area. When the federal government has spoken in the area of gasoline pricing or this, that, or the other, then the state cannot intervene in that area where it's obvious that they've sort of controlled that issue and controlled that domain, even absent an express preemption. So, sorry for taking us on a tangent, but it seems there's some overlap or some similarities philosophically between the two doctrines that we're dealing with here.
And that may be, Your Honor, and I think that is an apt thought progression, but the Act itself, the Public Records Act, says that exemptions need to be explicitly provided in statute. So, I just don't think that there is some sort of implied preemption here. It has to be explicit.
It's not implied, Your Honor. It's in there. It says if there's a other statute that preempts it, and then when you go to the election statute, it says that. And I would
What's the specific preempting statute? What's the exact? Let's get down to brass tacks. And what's that?
29A.60.110.
Stand by. I'm looking at it. 29A.60.
Yes. This is the only way that ballots can be accessed.
What's the 29A.60? 110. I'm pulling it right up so I can follow along. Thank you.
And I would like to point out that everything that I said about our voting machines, I relied on our election supervisor's sworn testimony, and I really object to being called less than truthful. In 23 years of being a lawyer, no one's ever accused me of that, and I would submit that my testimony from my client is much more convincing than counselors' off-the-cuff remarks that have no basis in the brief.
So noted.
And I think it would be helpful for the county to explain the resolution process, because I think that is pertinent here, and it does provide for the display of a ballot image on a screen.
I think we're getting far afield.
Here's my inclination. It's a serious enough issue, and you're probably right. One of you is right. It's probably a black and white. One is right on this, and one is not. And I'm going to take a look at the briefing again, look at the statutes myself, drill down in there and see. My impression is, in terms of public records, in terms of how the elections office would go about its counting and whatnot, I can see that sunlight being the best disinfectant. All of that should be open to the public. Ballots themselves are kind of sui generis. They are kind of, and so I really need to analyze that and look at the briefing again and some of the cases and statutes cited by counsel. And I'll either provide you with a written decision or I'll note up for a hearing where I can give an oral decision on this.
Thank you, Your Honor. I
I think it deserves that level of attention. I don't want to just wing it.
I would also note, Your Honor, that this has been taken under advisement in other counties, and council has submitted supplemental briefing. I think you probably have been deluged enough, and I would ask that you cut us off on briefing and you go with what you have.
A response to that?
I would just say that the supplemental briefing in another case was pursuant to a court order to requesting such briefing. It wasn't.
I'm not going to cut off the briefing, but I am going to. I will say that other briefing should only be filed upon the court granting permission for more briefing, so that we don't end up with an endless. This is workable. I can chew on this. That's no problem. But I've had bigger and more monumental reading before. So anyway, I think it's been briefed and argued fairly thoroughly. I'm comfortable that I understand the issue, but I want to really give it that second and third look that it deserves, and then I will notify you accordingly.
Thank you very much.
Thank you, Council.